My dear students, today I am going to discuss an essential element of a valid contract, and that is free consent. In last class, we discussed two points of this free consent, and that was coercion and undue influence. And today we shall discuss other 3 points which are related to this free consent, and that is the misrepresentation, then fraud and mistake. Students, you know that if an agreement or a contract is induced by one of these 5, such as coercion, undue influence, misrepresentation, fraud or mistake, then then the contract or agreement is voidable agreement. It can be declared as void by the person who is the victim in the agreement. Now the first issue is the misrepresentation. Now we are first discussing what is representation, and when representation is made wrongly, then it is called misrepresentation. Now representation means the explanation of material facts of one party to another party in order to induce that party to make an agreement or to make a contract. When this representation is wrongly made, maybe innocently or maybe deliberately, when it is wrongly made, then that representation is called misrepresentation. Now, if there is a misrepresentation or the agreement is induced or influenced by misrepresentation, then agreement is voidable. That means it can be declared as void by the person who is the victim of this contract or agreement, or it can be declared as valid by the person who is the victim or who is the victim of this contract. Now, my dear students, there are misrepresentation in the following cases, such as positive assertion of unwarranted statements of material facts, believing them to be true, breach of duty which brings an advantage to the person committing it by misleading the other to his prejudice and causing mistake about subject matter innocently. There are some essential elements of misrepresentation, such as misrepresentation must be innocently made. One party should make it innocently without knowing the consequence, or unconsciously should do the representation wrongly. Second essential element is it must be proved as untrue. That means it was proved that it was wrong. Third essential element is that this misrepresentation must be related to the material facts of the agreement or contract. And the last essential element is that this misrepresentation was instrumental to make the contract. What is the effect of misrepresentation? If there is a misrepresentation in consent, in giving consent, then that agreement is or contract is voidable contract. So in this case, the contract may be affirmed by the person who is the victim of this situation, and also contract may be rescinded by the person. The second issue is fraud. Now, what is fraud? Fraud is intentionally deceive others. That means when one party intentionally deceives other, then it is called fraud. Now, how to make this fraud? Now, when misrepresentation is wrong, representation is wrongly made, deliberately or intentionally, then that is also called fraud. Now, fraud here means that it was not true, but the one party has explained it that it is true. And also sometimes active concealment is also called fraud, but there are some exceptions. For example, Mr. X is a horse trader and he knows that his horse is unsound, but he did not give this information to Y, the buyer. and Y bought it. Now in this case, it is not necessary to disclose the material facts to B by the A, the horse trader, because rules says that the buyer beware. That means it is the responsibility of the buyer to check the product at the time of buying if it is a movable product. Here horse is a movable product, so it was the responsibility of the buyer to check at the time of buying whether it was sound or unsound. So usually active concealment is fraud, but in this case if the product is movable product, then the active concealment cannot be treated as fraud. A promise made without the intention to performing it is also a fraud. For example, X purchases some certain goods from Y on credit without the intention to pay the dues to him. This is a clear case of fraud. Any other act fitted to the agreement is also sometimes fraud. Nowadays, there are different types of frauds emerged due to the development of information and communication technology. Now, sometimes there are some legal bindings to disclose the material facts to the buyer, and in that case, if buyer does not disclose the material facts, then it is also a clear case of fraud. For example, in case of immovable property, say for example Mr. X wants to sell his land to Mr. Y. Now it is the responsibility of Mr. X to disclose the material facts of the land to Y. If Mr. X intentionally does not disclose the material facts to Mr. Y, then it will be treated as a clear case of fraud. Now question is whether can silence be treated as fraudulent. Now silence usually is not fraudulent, but if the silence is equivalent to speech, and then that silence is treated as fraud. For example, if B says A that if you do not deny, then I will assume that the horse is sound, and A remains silent, and afterwards it was discovered that the horse was not sound. So in this case, the silence of A was equivalent to speech. Therefore, this is a clear case of fraud. Now, the third point is the mistake. Now, mistake is the omission of related facts to the contract. So, if any related information related to contract or agreement is omitted unintentionally, then it is called mistake. Now, there are two types of mistake: mistake of law and mistake of fact. Now, mistake of law again is classified into two types: mistake of country law, mistake of foreign law. Mistake of country law. For example, if A and B erroneously believe that the date is barred by the law of limitation, then the contract is not voidable. Contract is valid. Mistake of foreign law. Mistake of foreign law is as like as mistake of fact. In case of mistake of law or mistake of foreign law or mistake of fact, in case of unilateral mistake, then contract is voidable, and if the mistake is bilateral, that means both the parties made the mistake, then contract is void. In unilateral mistake is always voidable, because one party cannot give blame to other party because of his own problem, because of his own mistake, because it is his responsibility to check and see the material facts of the agreement. If the mistake is so fundamental to the contract or agreement, so if there is a mistake of that fact or that root, then that agreement is void ab initio or void from the beginning. So, dear students, I hope that you have learned three aspects of free consent, such as misrepresentation, fraud, and mistake. So, in case of free consent, that means in a valid for a valid agreement, consent must be free, and consent will not be free if the consent is barred by this coercion, undue influence, fraud, misrepresentation, and mistake. Dear students, hope that you have learned something valuable regarding the one of the essential elements of a valid contract, that is free consent. Thank you.